Good morning, afternoon, and evening, ladies and gentlemen of the jury, depending on where in the world you are tuning in from today. Hello from Hong Kong, from the offices of Pillsbury, Winthrop. I was to join you live, but duty calls and pays, and so I have at the last minute decided, and Nick has kindly agreed to allow me to pre-record this session, as it seems that I may not be able to join live on account of work priorities. Indeed, if you're seeing this, it means that I was unable to join live. Busy days and nights for us attorneys at the moment. But given that I will not be able to take questions live, anyone tuning in is free to get in contact with me with any question, and I will do my best to answer. And I will not even charge my standard rate of 1,700 United States dollars an hour. As I have often heard myself in the Mercado Central de Maputo, for you, my friend, I give a good price. By the way, that's a wondrous, bustling, typical African market, which you should put on your bucket list if you've not been there already, along with the rest of Mozambique, obviously. As I've said elsewhere, may aviation hasten the return to a day when, once again, the greatest distance between any two places on our planet is only time. Speaking of time, there's a literary passage from a favorite book that has often come to my mind over the past couple of months when thinking about the current and the near-term industry state that we are in. So allow me a few seconds to read it in order to set the mood for the discussion that's to follow. The book is Of Mice and Men by John Steinbeck. It's an American Depression-era classic. As happens sometimes, a moment settled and hovered and remained for much more than a moment. And sound stopped and movement stopped for much, much more than a moment. Then, gradually, time awakened again and moved sluggishly on. Gradually, time awakened again and moved sluggishly on. For the time being, however, recovery is difficult to conceive amidst the cascade of distress, default, and disputes that test the resolve of even the closest lessor-lessee and lender-borrower relationships in this industry, and in African aviation in particular. The history of the airline sector in Africa and elsewhere has been, and it will forever continue to be, marked by cyclicality and crisis. For any professional that's engaged in the business of aviation today, this is our generation's epoch-making crisis. Nothing that has come before adequately compares. And to use the legal term, we live in unprecedented times. So it's presently a matter of rather intense speculation which African airlines will survive the current crisis. Surely some will not. As for the would-be survivors, debate rages as to who, between governments and the private sector, will be their saviors, and on what terms salvation will be granted. There's an intriguing serendipity about the restructuring of airlines. The fortunes of airlines in Africa and elsewhere largely depend on the fortunes of nations, and the reverse also holds true. While the fortunes of aircraft lessors, financiers, and investors very much depend on both. This is particularly true in Africa. Either way, contractual performance across the entire industry has become tenuous, and parties are left wondering if they can bridge the gap. So here I am to give you a brief, high-level survey of the key issues that we have been seeing, particularly in the African continent. So thus far, I believe it's fair to say that contractual ruptures in the industry and in Africa, in African aviation, have been largely contained. The sanctity of contract continues to be respected because pretty much intuitively, everyone knows that these contracts are made by lawyers to be enforced by lawyers. That said, perhaps less intuitively, contracts are also made to be broken. It's just that when they are broken or breached, there are consequences. And generally those consequences consist of payments of cold, hard cash that must be handed over by the breaching party. There are, of course, practical constraints, and when all else fails, tried and true tested dispute resolution in bankruptcy systems function as the ultimate last resort. But let's step back. There are 3 friction points to keep in mind. 1, contractual outs. 2, excused performance. And 3, limitations on remedies. There are also 3 main points to keep in mind concerning the timing of the contract and where each point in time falls, whether it's pre or post-COVID crisis. These are 1, signing, 2, closing, and 3, perhaps most importantly, performance. The legal regimes that are most often interacting with in the context of African aviation are, in order, English law, New York law, and the Cape Town Convention system. While there are hundreds of different types of contracts that are relevant to aviation finance, the main contract types of interest that have caused the most friction in African aviation to this point in this crisis are 1, operating leases, 2, loan agreements, and 3, new and used aircraft purchase agreements. Okay, so with that picture in mind, let's talk about the most typical contractual hotspots in the realm of contractual outs, excused performance, and limitations on remedies that we are seeing attempted or discussed in African aviation in the context of operating leases, loan agreements, and aircraft purchase agreements, which are in the performance stage of their lives at present and governed under the New York or English law regimes and where Cape Town does apply. So first, operating leases. In terms of contractual outs for aircraft that are to be delivered, it's delivery condition provisions that are typically being looked to by lessees. In the realm of excused performance, the most talked about item is so-called hell or high water and other waiver of defenses provisions. Lastly, in the realm of limitation on remedies for breaches of contract, the hotspot is very much termination of operating leases by an airline in some form of bankruptcy protection. The key issue when it comes to hell or high water and other waiver of defenses clauses will always be whether the hell or high water clause itself is always enforceable. The short answer is usually, but not always. This is why it's important to always include key language in the lease in the first place, because absent hell or high water language, for example, COVID and other government shutdown orders could partially or fully excuse a lessee's rent payment obligations under the doctrine of what's called force majeure. Now, if the lease agreement contains a force majeure clause for the benefit of the lessor, it generally makes express that such force majeure does not excuse the lessee's payment obligations. Loan agreements are interesting because we are actually seeing most contractual out discussions in the post-signing but pre-funding stage. And that very much focuses on the market funding disruption provision in the loan agreement in question. And it is the lender's that are making the argument. Excused performance in that context tends to focus on breaches of financial covenants by borrowers, whereas limitation on remedies tends to focus on the concept of what's called commercial reasonableness under Cape Town. Now, finally, discussions in respect of purchase agreements, again for both new and used, focus primarily on MAC, MAC, material adverse changes. Now, these provisions, whereas the hotspot in excused performance situations tends to be excusable delay provisions, which are in favor of buyers. Finally, when it comes to limitations on remedies, the hotspot naturally tends to be the contractual provisions that prescribe liquidated damages as the maximum allowable damages that can be claimed against the defaulting party, whether that's the buyer or the seller. Generally speaking, for sophisticated commercial parties, which includes all airlines and all lessors and all banks, rightly or wrongly, the relief is limited to either, one, private or public capital infusions, two, forbearance and restructuring, or three, tried and tested court processes, including bankruptcy court processes. Now, in the time remaining, and given the wide nature of the audience, I want to focus on different aspects of the airline restructuring perspective and the lessor enforcement perspective separately. I think that'll be the most useful way to proceed. The African airline seeking to restructure its aircraft fleet, in our experience in bankruptcy or some kind of creditor protection, has to protect and develop a viable fleet plan that provides sufficient aircraft for its restructuring operations at an acceptable overall cost. That's the name of the game. The airline will also need to formulate restructuring proposals that are consistent with that fleet plan to negotiate with its leasing and financing parties. The airline's collection of an analysis of information and its development of a fleet plan and its formulation of a formal restructuring proposal that are both economically viable for the airline and consider the perspective of the lessors, together with the flexibility to make adjustments to each individual restructuring proposal, or the fleet plan as necessary, will enhance the likelihood of an overall restructuring of its aircraft leases and financing arrangements. A critical early step for any African airline going through this process is indeed the collection and analysis of information for each aircraft. So what is that information? A, age and maintenance condition. B, the lease economics, which are the rent, the term, the maintenance reserves, return conditions, and security deposits. C, some understanding of the appraised current market rental and sales value. D, the actual structure of the lease and any related financing attached to it, even if it's a lessor financing. E, lease parties, their identities and the current notices addresses. And finally, factors affecting the lessor bargaining power, i.e. whether the lessor has a large block of aircraft, whether there's lease cross-default provisions, or there's lessor involvement in other transactions with the airline. And as part of all this, the airline should consider the structural or other potential hurdles to implementing its proposed restructuring. Whether the lessor has pledged its lease in a financing or in a debt equity, or any kind of foreclosure issues in the case of a leveraged lease. Also at an early stage, the airline has to analyze the protections that are available to it and the rights and remedies that are available to the lessor under applicable law. this is where it gets a little bit interesting these days, because applicable law will affect the bargaining power and the tactics of the parties and timing and processes for the restructuring and the bankruptcy, which is a whole other topic of filings in the US and in England. But if lessors are stayed from exercising repossession remedies for only a limited period of time under any applicable bankruptcy or insolvency regime, the airline has to be prepared to distribute the restructuring proposals to the lessors immediately upon whatever filing it makes in whatever bankruptcy court for whatever insolvency protection, in order to have the maximum standstill period to try to reach an agreement with each lessor. So don't wait. The airline has to also consider how its restructuring proposal economics compare to the current market values. So in any such instance, a premium over the market economics may speed up a lessor's agreement, and locking up more aircraft restructurings early in the process is only going to be to the favor of the airline, and it'll help improve the airline's flexibility and its options with the other aircraft that have not yet been restructured. So in legal talk, time indeed is of the essence. Now, the lessor's opportunity cost of accepting an airline's restructuring proposal is the lease or sale economics that another operator or buyer is willing to pay, minus the cost of repossession, remarketing, and any additional refurbishment to meet the required delivery condition for a lease or sale at that point in time, pursuant to the prevailing market realities at that moment in time. So on that note, the lessor, when push comes to shove, hopefully not literally, may need to repossess the aircraft. And in doing so, this is from the lessor's perspective now, we typically advise lessors to allow for adequate time for marketing, inspections, and diligence, etc. Typically 60 to 90 days should be viewed as a minimum in a difficult market, and lessors should allow for COVID-related delays, i.e. to physical inspections. Next, we advise them to get independent appraisals based on actual condition of the aircraft and documentation, and also document their efforts to value the collateral. Separately, value claims and metal. If the equity is not underwater, they should consider a private sale process, but noting that a choppy market requires digging behind bids to look at factors, including the counterparty's ability to actually close, and also noting financing contingencies, inspection outs, hard security deposits, etc. If, as is often the case at present, bids are below debt levels or equity is underwater, then the secured party may, the lessor or the financier may undertake a public auction at which it can, credit bid. In doing so, they have to ensure that the borrower can bid at the auction and that COVID-related procedures are also followed. Also, avoid any onerous bid procedures which could be interpreted as chilling the market. And further, if possible, separate the collateral into lots where this is reasonably likely to increase interest and bid price. But generally speaking, our advice to lessors and financing parties that have enforced is expect additional scrutiny on fairness and process, and keep in mind that the standard is reasonableness, not perfection. So in closing out, I note that in many ways our experience has been that the limited remarketing possibilities at the moment are in fact what aligns the interest between lessors, banks, and airlines. So in that sense, for better or worse, we really are all in it together. Thank you, Nick, for bringing me to this event and bringing this event together online for the first time in its history. In a different lifetime, when we did coalesce in person or in Addis or Joburg, wherever we were on that beautiful continent, this conference was my favorite on the calendar. Indeed, it was and now virtually is good times with good people, but I look forward to the point in time when we all get together in person again, and I hope that it is sooner rather than later. And I believe that is 20 minutes almost on the dot. And I thank you all for your time. And I'm happy to take any questions you have after the conference as well. Thank you again.